We have a practical look at MIPI's IPR framework here from Brad, who's MIPI Alliance's legal counsel. Obviously, all of the mass specifications that have been presented today are all subject to the MIPI IPR policy framework. We often get questions raised out in this area. There seems to be sometimes some confusion about how the policies are applied. So it's great we've got Brad here to explain all, and I'll hand over to Brad to take it away.
As Ian mentioned, I'm the outside general counsel for MIPI Alliance. I'm part of a small law firm, a boutique law firm, 3 lawyers essentially, and some staff folks who we support standards organizations. So this is what we do. Prior to this launching this practice in 2015, I was standards counsel for Intel, and which is an interesting place to learn standards. Intel's involved in a lot of different organizations. I'm also a part-time academic. I'm a faculty fellow at Arizona State University, where my research focuses on standards organizations. I live actually though in Portland, Oregon, despite being affiliated with ASU. In terms of the substance I'm planning to cover today, it's really two main points. One is that the MIPI IPR, intellectual property rights terms, I believe are particularly well suited to circumstances in the automotive industry. I think this is a point that's been underappreciated and also is like potentially like extremely consequential. So I really want to make this point clearly. It's a bit nuanced, and so it'll take a bit of explanation, but I think there's a really important issue here that the MIPI IPR terms are quite well suited to the automotive industry. I'm also going to talk about the way MIPI licenses out its specifications. I think there's been a bit of confusion about this. The way MIPI does this is a little bit different than some other organizations. I think the rules that MIPI uses are very good rules that are quite effective to benefit its members, to benefit the industry. So I want to take a little bit of time to explain those. So starting with the point about the royalty-free IPR terms, I mentioned I do some academic work. One of the first articles I wrote on standards back in 2010, I just started doing the role at Intel where I was focused exclusively on standard setting, and I gotten curious about, I'm looking at a laptop computer, how many standards are in this computer? And I didn't know even as an order of magnitude, is it more like 50, more like 500? And so that was the main point of the research, was to analyze, how many standards are in a laptop, and we counted 251 standards at that time. But one of the things we did when we were doing that work was we bucketed the IPR policies associated with each standard into 2 main categories. One category of FRAND or RAND, which for our purposes today are synonyms, and another category of royalty-free. So most at the time standards are produced under RAND or FRAND terms, which means that so fair, reasonable, and non-discriminatory, meaning that if I contribute some technology or I otherwise have a patent that reads on an implementation of a standard, I make a promise that I will license my patent or my patent claim on reasonable and non-discriminatory terms, which potentially could include a reasonable royalty. So that's the category of RAND or FRAND. Then there's the category of royalty-free, and it can have different terminology, can be different, but it can be RAND 0, reasonable non-discriminatory with 0 royalty, or royalty-free RAND. But the fundamental concept on the royalty-free bucket is that I, as a participant, promise to license my standards essential patents or my standards essential patent claims on royalty-free terms. Oops. In maybe unsurprisingly, there are some common disputes that come up, particularly that come up in the FRAND or RAND context. And one of the disputes is, what's a reasonable royalty? I mean, in some respects, this whole model is kind of crazy. That you can't, like, if you imagine buying a car, and saying like, okay, I'm going to drive this car off the lot. You agree to charge me a reasonable price, and we'll just decide later what the price is going to be. But in the context of standards, there's really no other choice. there are other choices. But if you're going to use a royalty bearing approach, it would be almost impossible it would be literally impossible to figure out up front, what patents are going to be essential and so forth. So the RAND model is kind of the least bad option, but it's, but there's definitely, opportunity for dispute about, okay, well, what's a reasonable royalty? And we see when these kind of disputes come up that they, sometimes parties are off by multiple orders of magnitude, where, in both arguing, oh, this is a reasonable royalty, but in some cases, literally 2 orders of magnitude apart from each other. So that's one big dispute area that comes up. The other that's a little more nuanced is around, is it the non-discrimination prong of FRAND or RAND, which is, can I, a patent owner, decide that I'm only going to license at the OEM level, or the party who's manufacturing the end product, or do I owe a license to parties that are in other places in the supply chain, so a component manufacturer? And these disputes are very real. So this is not at all theoretical, and very real in connection with the automotive industry in particular. I commend this webinar that's mentioned here on the slide. It's that walks through some of the litigation. But for our purposes today, the main point is there's a lot of litigation happening right now that's directly related to these kinds of issues. So it's a big deal for the industry. The MIPI IPR policy is in the category that I framed up as royalty-free. And so this, on the slide right now, you'll see a excerpt from our IPR terms, or from our membership agreement, the part that addresses the IPR terms. And the key point to take away here is that the obligation that MIPI members make is to grant royalty-free licenses to all other members. The grant's actually a live grant. Hereby grants this license without compensation. So on the reasonable royalty point, you can see how that plays. On the non-discrimination point, the key idea here is that every member, at no matter what level of supply chain, is a licensee, gets a license. This is a pretty big deal. If we think about these 2 different prongs, in terms of looking at most of the organizations that are focused on standard setting for in the automotive industry right now are more traditional RAND or FRAND organizations. So there's the potential dispute about what's a reasonable royalty. There's also potential dispute around at what level of the supply chain are licenses owed. One organization, IEEE, has somewhat controversially tried to address the what we call level discrimination, where licenses are owed, but MIPI really stands alone in terms of addressing kind of both of those issues. And this is, as I mentioned, very highly consequential, potentially. So, like, for example, if you're a supplier and you have to make a promise in your contracts with your customers that you're going to indemnify and pay for IP disputes that your customers face related to your product, it's a big deal to know that you are licensed on a royalty-free basis to patents that are essential patents that are embodied in your product. And similarly, it avoids the problem of having to do patent clearance. So if you're manufacturing a product, you might decide, oh, I'm going to go and get licenses to all of the owed RAND licenses. I'm going to go get RAND licenses. But in the case of MIPI, you've already gotten a royalty-free license. So I'm going to shift gears. So that was main point number 1. Main point number 2 is related to the way MIPI licenses out its specifications. So MIPI specs are confidential to members, and as I mentioned, the model MIPI uses is different than some organizations. So MIPI specifications are confidential to members with some key exceptions. So I3C basic, a number of the debug specs, so there are some specifications that MIPI's made publicly available, but generally confidential. then, so when you think of something confidential, it's another way to think of that is it's a trade secret, in the sense that it's something that's valuable because it's not widely known. And so when use rights are granted to that, it's a limited trade secret license. And so what MIPI does is says you can use these confidential specifications only for the purpose of developing products compliant with MIPI specifications. We also have copyright licenses associated with our specifications. So these specifications, parties make contributions. The collective, work end product is something that's copyright. The copyright is controlled by MIPI. MIPI licenses that out. And similarly, on the copyright license side, we limit the way our specifications can be used, only for the purpose of developing compliant specifications. So there's a contractual agreement, and then there's background trade secret law, copyright law that's relevant. This is good for MIPI, for our members, for the industry, because it enables the organization to, kind of create rules about how its specifications can be used. And so, for example, and this I'm using a particular example because this has been an area of a bit of controversy. We have a rule in the specification that says our protocol specifications, in this case, example DSI, must be used with a MIPI physical layer specification. Or other PHY specs authorized by the board. So applying these rules, using a non-MIPI PHY with a MIPI protocol would be definitionally non-compliant because we have a rule about what constitutes compliance. MIPI specs per the slide before can only be used for the purpose of developing compliant, products. And so using so violating this rule would be, raising concerns about, on the trade secret license side, on the copyright license side, etc. There are other tools that support this as well, but really fundamentally, this is sort of how this works in practice. So let me just make a little finer point on this one because again, this is a topic that's been a bit controversial. So on the issue of that particular rule of coupling PHYs and protocols, I think the legal issues are I think crystal clear. Like MIPI decides how its specs are going to be used. And MIPI has made a decision, and it's articulated in our specifications about how its specifications can be used. But it's the legal rules support a business and technical choice. So the MIPI leadership has made a business and technical decision that for reasons of technical quality, for reasons of minimizing fragmentation in the industry, for reasons based on 15 years plus of experience that coupling PHYs and protocols is sort of good, is ultimately good for the industry, has made this business and technical decision that's then supported by this legal framework. There has been some what I call loophole seeking in this context, where we see organizations, other standards organizations that have not liked our rule and wanted to use our specs in ways that are different from our rule. And the points I would make about that is that I hope that it's clear that the legal rules are just very clear on this point. And so violating legal rules has its own set of legal risks. But it's been a bit frustrating to me, actually, that it's even been we've had to make legal arguments about this, because I really think there's kind of a set of industry norms about standards organizations respect the work of other standards organizations, and when they are interacting with each other, it's via liaison agreements, and there's just a set of ways this has been done historically. And I think this whole model of industry-driven consortia has been really effective, for industry participants, and I think it's in sort of our collective interest as an industry to to respect these norms. And so and there's some potential harm that comes from organizations not respecting these norms. So legal issues aside, I think it's important to for organizations to engage in formal liaisons and really have agreement about how one organization uses another organization's specifications. And at the highest level, I would say even there's really sort of an ethical question around I've been surprised that other organizations or companies, who are participating in other organizations that would never just take some other, company's IP, without a license, have seemed to think that it's somehow different in the context of standard setting. And so I do think there are reasons, above and beyond the legal rules. I think there are some important reasons why these kind of norms should be respected. I think I am technically out of time, but let me just do a very quick recap. So again, really two main points. Our licensing structure is uniquely well suited for the automotive industry. I really do think provides some significant advantages over alternative models. And then secondly, the point I had just made previously, that we do have these specific rules about how our specs are used, and those rules are good for our members and good for the industry. So I will stop there and see about questions.
Okay, thank you, Brad. Good, nice, clear presentation. Thank you very much. So yeah, if you have any questions, please submit them now through the Q&A box, and we'll do our best to answer those. Got a couple of questions up my sleeve, as always. Any good moderator has. First one, Brad, obviously you mentioned that MIPI applies a royalty-free patent agreement, patent framework. It's only available to MIPI members. Obviously, automotive industry relies on long supply chains. So if I'm a MIPI member building MIPI IP into my products, and then I would obviously feed that into the automotive industry, how does that affect the companies further down the line?
Yeah, there's a nuanced point here around a topic called patent exhaustion. So if I'm a supplier and I make a component part, I'm a MIPI member, I build a compliant portion. My compliant portion is licensed under the MIPI IPR policy. At that point, there's this concept that applies called patent exhaustion. So that license sort of benefits everybody downstream from me. So a patent owner can't say, oh yeah, I granted a license to Brad, the component manufacturer, and now I'm going to also assert that same patent against downstream people against that same product. So those downstream parties are actually benefit from my license, even if they're not MIPI members.
Okay, thank you, Brad. I guess the other question is, you mentioned that obviously the royalty-free terms that MIPI applies, and the fact that other organizations use FRAND, RAND. I mean, can you just reiterate the benefits that the MIPI policy brings to the automotive industry?
Yeah, I mean, there's you could argue, well, maybe there's drawbacks. You could, I think there's a case for FRAND and RAND, which is the argument is typically we'll get better contributions, that the higher quality contributions will come in because the parties incentivized to make contributions can make money, royalty money downstream. I think for us, what we've seen is we just have this experience over and over of we're getting like incredibly high quality contributions and under the royalty-free model. So we have evidence that MIPI specs in the telecom space competed against lots of other things and really kind of won out over alternatives because the technical quality is extremely high. And so we really are sort of having the best of both worlds. We are able to get high quality technical contributions under our royalty-free model because parties are incentivized for other reasons to make high quality contributions. And then we get the benefits on the implementer side of all the benefits I walked through about why the royalty-free model is best from the implementer perspective.
Thank you, Brad. Okay, we have a question coming here about the use of SerDes bridges. Kind of a question we probably expected. Obviously, we see that there are proprietary SerDes bridges, bridge components in the market that use CSI2. They've been available for some time from various vendors. Perhaps you could just talk about the IPR policies that apply to these bridged solutions versus perhaps an integrated solution where the PHY is integrated into the sensor and into the ECU.
Yeah. So I think partly, sort of watch this space. So I know we've been getting questions about this, and there's been some requests for information. So I think this is something that we're still, trying to be responsive to, industry, desire for more clarity. We have talked about this quite a bit. We have some other blog posts that I wrote, for example, that's posted, and that addresses this. It's so that's another place to look, is our published documents. Basically the key point, I think, is that we have our rules. Our rules are clear. We expect our rules to be followed. There's as the key, when something comes with a MIPI implementing compliant portion, it outputs a protocol over a MIPI FI. That's really, the key point, is that's our rule. Bridge from the bridge chips on down. There's a question. I understand there's some nuance about exactly what happens in terms of. Sorry, and also sensing we're over time. So let me just say this. Our focus is on the compliant portion, which is coupling, protocol, and PHI. We have some public postings in our blog post, for example, about what happens with bridge chips. Generally, our view is there's some flexibility in terms of implementation once we have the compliant portion. Data coming off the compliant portion is to some degree sort of like an implementer zone where MIPI doesn't take a position about exactly how that looks, and we will be looking to try to add additional clarity on this point, because we know there's a desire for that in the industry.
Yeah, thank you, Brad. And yeah, I mean, I would iterate there. We have, Brad has written a blog, a very good detailed blog about this precise subject. It's in the MIPI blog. I think it was written some time ago now. I think it was maybe almost 12 months ago. So please search through the blog. You will find it, and it does offer that clarification. And obviously, we'll do what we can to offer further clarification going forward. We do have a couple more minutes, Brad, until we need to switch over to the next presentation. I guess I'll ask the kind of question that might be in a lot of people's minds. Why doesn't MIPI just makes its specs available to everyone? Why insist on this member-only model?
Yeah, so we do in some cases. Which I think is there's in some particular cases, I think it's actually quite useful, and good for our members and good for the industry to have the specs publicly available. And so the MIPI strategy really has been, where that makes sense because of some particular factors around, for example, needing to have support from like the Linux community or the software development community. We have that kind of tool in our toolbox, to open everything up and make it available publicly to support, whatever sort of goals ultimately support the industry and our membership. But I think in general, what we found is our model really works. It works because we have good reasons for people to be, sort of inside the MIPI tent, working with us collaboratively to develop our specifications, to improve our specifications. Our licensing model, member to member, has been very effective. And so I think we really end up having sort of the best of both worlds, where we have, high quality specifications, deeply engaged membership, with this royalty-free IPR terms, with some rules that enable us to, kind of put a framework around how our specs are implemented in the world. And when we need to, we will, make the specs available publicly to help support other strategic goals.